Good afternoon, everybody, and welcome to today's virtual discussion, The Indian Law Bombshell, McGirt versus Oklahoma, a virtual discussion with Bob Miller. My name is Patrick Spiro, and I'm the librarian of the American Philosophical Society, and I'm zooming to you from our campus in Philadelphia. And before we begin, I'd like to acknowledge that Library Hall, the building in which I sit today, and the rest of the Society's campus sit on the homeland of the Lenape people known as Lenape-Hoking. I want to recognize their historical relationships with this land that continue today. The American Philosophical Society recognizes with respect their continued presence and perseverance, and we express our sincere thanks for the past and ongoing generosity of numerous indigenous communities and individuals who have offered their guidance, expertise, and opportunities for collaboration. In fact, one of the greatest new initiatives in the American Philosophical Society has relied upon those relationships and that generosity. It's our Center for Native American and Indigenous Research. And if you're unfamiliar with CNAIR, I encourage you all to visit our website to see what the Center for Native American and Indigenous Research is doing, and also our collections that may be useful to your own research or work. You can visit our website at www.amphilsoc.org. And in many ways, our guest today, Bob Miller, has been at the forefront of the Society's efforts to do more with its Native American collections. I've gotten to know Bob really well in the past 6 years that I've been at the Society, but Bob's relationship with APS goes far longer back. Beginning in the early 2000s, Bob helped advise the library to think more and more widely about its Native American collections and how they can be used. Since that time, Bob has served in a number of different capacities. He serves on the Center for Native American and Indigenous Research's Advisory Board. He serves on the Library Committee. He serves on our Research and Grants Committees, the Phillips Fund. And of course, he's also an APS member who serves the Society in a wide range of other capacities. So I'm thrilled to invite my friend, my advisor, Bob Miller, to give a talk today. Now, Bob's academic and scholarly career is extremely distinguished. I have a long page of all that he's done, but I know everybody just wants to hear him talk. So I'll try and be as brief as possible about his own background. Bob currently is a professor of law at Arizona State University. He also holds the Distinguished Research Scholar, a position that he was appointed to in 2019. He was elected to the American Law Institute in 2012 and the American Philosophical Society in 2014. He's published a number of books and important articles. He specializes in federal Indian law. I personally got to know Bob first through his scholarship in his first book called Native America, Discovered and Conquered, Thomas Jefferson, Lewis and Clark, and Manifest Destiny. And if you haven't read that book, I encourage you all to check it out. He's gone on to publish several other books and numerous articles. And so without any further ado, I want to introduce Bob Miller. But first, a few housekeeping matters since we're using Zoom. The first thing I want to note is that we are using the webinar version of Zoom. So that means the best way to ask questions is through the Q&A feature at the bottom of your Zoom panel. You can see that on the bottom of your panel, it says Q&A. Please ask us questions as soon as they come, and we will have time to ask as many of them after Bob's presentation. In addition, I hope you'll check out all of our virtual offerings on our website. Our next talk is on Tuesday, December 8th at 4:30. We have another one on December 9th at 1 p.m. So please check out our website. All of our virtual offerings are on our website, and I hope to see you all virtually again in the future. So with that, Bob, you want to take it over?
I'm delighted to get to speak today to the audience and to continue to work with the APS. Thank you, Patrick. Thank you, Adriana and Kyle and everyone at the APS that's involved with helping me to put on this topic. I'm talking about what I call the Indian law bombshell. I suppose some people think I'm overhyping this case, but I'll let you be the judge of that after we discuss it today. I literally think I'm going to be given a book contract to write about this case because it appears at this moment to be that significant of a case. I call it the Indian law bombshell. July the 9th, 2020, I woke up in the morning and the Supreme Court had issued on its last day of the last term, it issued McGirt versus Oklahoma. And that's the case that I'm going to be talking about today. I call it a bombshell because the changes it's going to lead to, what it portends, what it promises in Oklahoma is a significant and substantial readjustment of state, tribal, federal relations, governance, criminal jurisdiction, civil jurisdiction, adjudicatory jurisdiction. I will talk about these issues in the last few minutes, what I'm foreseeing we might see changes in Oklahoma. Oklahoma is concerned. They've made suggestions that Congress pass a bill to undo McGirt. And at the end of today's talk, I will discuss with you that who knows, maybe the McGirt decision could be changed by the Supreme Court itself with the passing of Ruth Bader Ginsburg and a new justice. Anyway, we'll save that for the last. But anyway, let's get started. I'm going to try to share my screen here and see what my PowerPoint file looks like. And I think that I hope I'm in the thumbnail, and here's my PowerPoint slide. So July the 9th, 2020, I woke up. I truly did not think we would win. The tribal argument would win this case in McGirt, but it did, and we were going to talk about the impact. Let me just briefly tell you what the case is about. Mr. McGirt was convicted of heinous crimes in Oklahoma state courts, sentenced to something like 1,000 years in prison, later reduced to 500 years. His defense was, and how this issue got raised of whether the Muscogee Creek Reservation still exists. And that's what this case is about. What we in Indian law call Indian country, folks. The Congress in 1948 enacted a statute, 18 U.S.C. 1151, that defines what Indian country is. These are the areas, the primary areas of tribal nation governance, criminal civil jurisdiction, etc. So Mr. McGirt's attorney argued that he's an Indian. The crime he committed was within the boundaries of the Muscogee Creek Reservation. Ergo, the state of Oklahoma had no criminal jurisdiction over him. The Supreme Court agreed with that argument, and that's what we're going to analyze today. And so now the Muscogee Creek Reservation, instead of being tiny little allotments that might have encompassed 120,000 acres of land, now the Muscogee Creek Reservation is 3,250,000 acres in eastern Oklahoma. On the morning of July the 9th, 1 million Oklahomans woke up and found out they live on an Indian reservation. 400,000 people in the city of Tulsa, Oklahoma, found out the morning of July the 9th that they live on the Muscogee Creek Reservation. I think I could almost stop my talk now. If that doesn't sound like a bombshell or just people were concerned, there were people saying, gee, what happens to the title of my house? So these are the issues we're talking about. But we got to go way back in time, folks. And when I talk about Indian law, I cannot help, and Indian history, I cannot help but start with this letter by George Washington. This letter might actually shock some of you. He was the general in September of 1783. We just had signed our treaty with England to end the Revolutionary War. The existence of the United States looked to be guaranteed. England wasn't going to attack us tomorrow. And so the Congress asked George Washington, what should we do about the tribes? And he writes this 4 or 5 page letter that is known as the Savage as Wolf letter. And I'll show you the text in a moment. But in the last page is the stuff I want you to focus on. What was the goal of Euro-Americans when they came to this continent? What did the settler colonialists want? Well, they wanted the land, they wanted the assets, they wanted native peoples to disappear. That's pretty much the story around the world. But to see what George Washington wrote in black and white here, I think is a little stunning. So he advised Congress this: the Indians will retreat as we advance. He says it's cheaper to buy the land from them than to fight wars with them. So he was advocating just the gradual advancement of the American frontier. Look, again, he says economy and policy point to the expediency of being upon good terms and buy their lands instead of trying to drive them away by force. Now, here's the key part. which, as we have already experienced, is like driving the wild beasts of the forest. Now he plainly analogizes Indian peoples to animals, and that's why this is called the savage as wolf letter. I underlined the key language. He said, why try to drive Indians away? Because just like the animals, they will just naturally withdraw. And look at last section, both being beasts of prey, though they differ in shape. Now, I hope that chills you as much as it chills me. George Washington, this benevolent father of our country, had a different vision for the indigenous human beings that lived here for centuries, governed, owned, controlled the lands, and were the inhabitants. They were just going to magically disappear, like, I guess, the animals. So I'm not going to interpret that language. You read what George Washington's saying there. So is this what followed in American policy? Absolutely, folks. And until about 1960, this was the federal policy, that Indian peoples were inferior cultures, inferior humans, I guess, and that they would naturally be overwhelmed by the superior civilization, the superior forces, the superior arms of, what word should I use? Non-Indian Americans and the United States. If you've seen these maps, I'm not going to belabor this a second, but you've seen what happened. And what we're talking about, look at the map on the lower left-hand corner and look at the eastern part of what's now Oklahoma. This was the Indian Territory. This is where my tribe is located today. This is where the Muscogee Creek Nation is. And so this is where this case that we're talking about arose. So we're talking treaties. We're talking promises that tribal nations signed with the United States in good faith, and promises they expected to be fulfilled by the United States and kept forever, if that's what the provisions of the treaty said. So I just want to show you the Article 6 of the Constitution. This is called both the Treaty Clause of our Constitution, but it's also called the Supremacy Clause. I'm certain you've all heard of that phrase. Federal law is supreme in those areas that the Constitution reserves that power for the feds. So this Constitution, the laws of the Congress, and all treaties made, that's a reference to past tense treaties the United States had signed with tribes like my own. The Shawnee people signed a treaty in 1786 with the Articles of Confederation Congress, or which shall be made. The treaties the United States would yet sign are the supreme law of the land. That sounds pretty solid. So the treaties that Indian tribes signed should be honored, right? Didn't the United States pledge its honor and its faith to keep these promises? But let me show you this point here, folks. The Supreme Court has long held that Congress can unilaterally abrogate even foreign treaties. If you're aware of what are called the Chinese exclusion cases from the 1880s, Congress abrogated treaties the United States had with China about the admission of Chinese people into the United States, and the Supreme Court upheld that. And a decade later, in the Lone Wolf case, the United States Supreme Court said Congress can unilaterally abrogate Indian treaties too. So just briefly to, what is a treaty? There are 375 of them that were enacted in those time period. The Supreme Court not that long ago said that treaties are contracts between nations. So just to understand a treaty, what is it? It's an exchange of land and assets and power and promises, and it's a contract that should be binding on these governments. But remember this last clause, Congress can unilaterally abrogate treaty rights. And that is an important point to the McGirt case and what we'll be talking about when we get to McGirt. United States versus Winans in 1905, that was a fishing treaty rights case out of the Pacific Northwest. The United States Supreme Court defined treaties as a reservation of tribal rights. Excuse me. What the tribe did not agree to sell to the United States, it reserved for itself. Folks, I think that's one of the primary reasons we call Indian lands today reservations. It's the land that the tribe reserved for itself to keep in perpetuity among a much greater area of land that the tribe maybe exercised Aboriginal rights on and agreed to sell to the United States. If you're unaware of this, in Canada, they call Indian lands reserves. They did not borrow our word of reservation. This word reservation, and when it became a term of art in federal Indian law, is crucial to the McGirt case. So let's start talking about the treaties. The Removal Act, you probably all know the word, the Trail of Tears. What was that about? Well, part of enforcing George Washington's thinking, the savage is wolf, and Thomas Jefferson wrote private letters when he was president, folks, in 1803. So the idea of removing all tribal peoples and all Indian nations west of the Mississippi was around long before Congress enacted what's called the Indian Removal Act in 1830. Congress barely had passed the law. It was a very close vote in both the House and the Senate, but it became federal policy to remove tribes from the east of the Mississippi to the west. The act required the consent of the tribe, so it took treaty making. My own tribe was put under great pressure to move. We were located in about south central Ohio, and in 1831, we signed a removal treaty. And in 1832, September to December, we moved to the very northeast part of what's now Oklahoma. But we're talking about the Creek. The United States negotiated with the Creek. The United States threatened the Creek. President Andrew Jackson said, if you stay where you are, we will not protect you. You will be under Georgia state law. Good luck with that. And that was the Fed policy. That's how they forced what are called the 5 civilized tribes in the American Southeast, the Cherokee, Chickasaw, Choctaw, Seminole, and Creek. Andrew Jackson threatened to abandon them, to leave them to the mercies of the state court, state governments. And Jackson said, you better move west. Cherokee were even rounded up and marched away, I think, by bayonet. So there was also force done. But anyway, the Cherokee saw the writing on the wall, Creek, saw the writing on the wall. They said, we will move west. We will sell you all our land in the east for various promises and various compensation. You will provide us replacement lands in the west, education, blacksmiths, and various gifts. The nation, this is an interesting point, folks. If you understand how Indian nations own their land today, it's in trust with the United States. Tribes in the lower 48 states own 56 million acres of land, but in trust with the United States. The United States is the legal owner. The tribal nation is the beneficial owner. Individual Indians, due to the allotment era we're going to talk about in a second, own about 11 million acres of land in the lower 48 states. Again, the United States is the legal owner. The individual Indian is the beneficial owner. But the Muscogee Creek Nation says, we want a fee simple title so that you can't force us to move again. They must have read George Washington's 1783 letter, and they knew what federal policy was and the federal goal. So they demanded the fee simple absolute title. That's the way you and I own our homes. It's considered the highest, strongest form of real property land ownership in the Anglo-American property law system. But look at the other promises the tribe secured from the federal government. It'll be our permanent home. You solemnly guarantee it to us. We will govern it. We will never again be under state or even federal territorial law. The United States agreed to this. It's binding federal law under Article 6 of the Constitution. It's the supreme law of the land. This map you can look at just a second. My tribe's actually a little lower in Ohio than the other Shawnee peoples that were also removed to what's now Kansas. But my tribe was a little further south in Ohio than what that map shows. And we moved to the very northeast corner of what was called the Indian Territory, now the state of Oklahoma. So once the Creek arrived in Oklahoma, they signed another treaty with the United States and selected an enormous 6 million acres of land. And the United States agreed it would be their lands forever. The tribe did finally receive the fee simple absolute title in 1852. They signed even another treaty, just like my own tribe. There's a multitude of treaties that many tribes signed with the United States. My tribe signed 11 treaties with the United States throughout a 150-year time period. Look what this treaty says. No portion of the Creek lands will ever be in a state. or annexed to a state or territory, the Creek Nation has the unrestricted right of self-government, full jurisdiction over tribal citizens and their property. The United States recognized the Creek Nation as a government, the governing entity for Creek lands, and agreed to these promises. Most of those were breached, of course. In the Civil War, many tribes in the Indian Territory, including my own, signed treaties with the South. These were almost coerced. They were almost forced because the Union troops withdrew from the Indian Territory. The BIA even withdrew the Indian agents that were ostensibly the go-betweens, and maybe some would say even in charge of these reservations. And so there was no one there but Southern troops. So in 1861, most of the tribes in the Indian Territory signed treaties with the South. The United States at the end of the war extracted its revenge. And in Fort Smith, Arkansas, they laid down the law to the tribes. They punished us all, and they demanded the cession of more lands to sign new treaties with the United States. The Creek signed a treaty in 1866, and there's some of the relevant points. They ceded half of that 6.5 million acres of land they had in Oklahoma. I'll show you a map in a second. The United States paid what looks like a pretty good price, only 30 cents an acre, but the eastern half was still, quote, forever set apart as a home for the Creek Nation. And look, for the first time, folks, the word reservation was applied to the Creek Nation. Now, partly, what did I say earlier? This became a term of art over time, and tribal homelands came to be called reservations. So this is a significant reference. The majority opinion in the Supreme Court in the McGirt decision emphasized this and say there's no question that the Creek Nation had a reservation. Oklahoma made an argument in the McGirt case, folks, that the United States, who supported the state of Oklahoma in the McGirt decision, the United States refused to join this argument of Oklahoma. But Oklahoma tried to argue that the Creek Nation had never had a reservation in the Indian Territory and what is now Oklahoma. And the majority just almost laughs about it. Look at this treaty. Look at that word. Obviously, the Creek Nation had a reservation long before there was an Oklahoma. If this is news to you, Oklahoma became a state in 1907. So this is a map just very quickly. These are the 5 civilized tribes. I named them earlier. They were forced to sell half their lands in signing these 1866 treaties at the end of the Civil War. My tribe, well, I'll show you the next map because I want you to see the most important tribe in the United States. Here, let me just go back one slide. I thought I had language there, but this treaty also forced the Creeks and these other tribes, when they sold the land in the west of what's now Oklahoma, it was to become the homeland for further tribes that were being removed. And so you can see on this more modern map, there are plenty of tribes in the western part of Oklahoma, these territories that the 5 civilized tribes were forced to sell. Now, of course, I'm only joking, folks, but the most important tribe of the United States is at the very top of the map there. That's the Eastern Shawnee tribe. And in fact, I'm wearing my tribe's symbol. This is our tribal symbol of the Eastern Shawnee. So this case, the McGirt case, is of extreme interest to my tribe and to these other tribes with small pieces of land. I'll mention this again at the end, but the Miami tribe up top there is going to have a court hearing in the trial court of an Oklahoma court, have a show cause hearing where evidence will be presented whether the McGirt decision requires the Miami reservation to still exist also. Oklahoma courts have already said that the Seminole Nation reservation still exists. Let me go back one slide because it's easier to see on this map. Seminole has the smallest reservation of these 5 civilized tribes, but an Oklahoma trial court has already held that the Seminole tribes' reservation borders still exist, just like the Creek. The other tribes and the small tribes in northeastern Oklahoma, the question is being raised now too. And again, it's often raised by criminal defendants arguing that they committed their crime in Indian country where Oklahoma has no criminal jurisdiction. Okay, I need to bring up the allotment era because this becomes very significant for all the tribes in Oklahoma, and it becomes very significant in the McGirt decision. Congress began in 1887 what's called the allotment. All I'm going to tell you is this is a perpetuation of George Washington's idea that over time, Indian country will get smaller and smaller, and Indian peoples will disappear, and Euro-Americans will have the entire continent. One of the famous Shawnee chiefs, folks, I got to tell you, Black Hoof in Ohio, he was against the Shawnee peoples moving from Ohio, because here's what he told the federal treaty negotiators. He said, if we once move, you will never stop moving us. So the tribal leaders knew what was going on. I doubt they'd read George Washington's 1783 letter, but they could read the writing on the wall, what the feds were doing. So once a tribe had a reservation of, let's say, 3 million acres, like the Creek Nation, Congress enacts the Allotment Act, which started taking small pieces of land within the reservation and allotting it to individual tribal citizens. Most of the laws gave 160 acres to a head of a household, 80 acres to the other adults over 18, and 40 acres for Indian children who were alive at the time that Congress enacted this tribally specific Allotment Act. Most tribes did not have enough citizens to break up the entire reservation. So Congress called the rest of the lands surplus lands and sold them to non-Indians. So today across the lower 48 states, folks, there are a lot of non-Indians who live within the recognized borders of Indian country. So I want to emphasize to you what is happening, going to happen maybe, what I'm going to predict at the very end is going to happen in Oklahoma is no different than how other states have been used to having Indian reservations within their borders. There's litigation, there's disputes sometimes, the Supreme Court defines certain things, but most of the issues that I'm going to predict will arise in Oklahoma are well understood and have been handled by other states and other tribes elsewhere. So in one sense, I want to downplay the fears of Oklahomans that this is the end of the world. It's only going to be a situation that other tribes and states know well. I teach in Arizona. Folks, 27% of the land in Arizona is owned by Indian tribes. You have enormous tribes, the Navajo Nation, the Tohono O'odham Nation, the White Mountain Apache tribe, they own enormous areas of land. 27% of the state of Arizona is governed by and owned by Indian nations. The state has accommodated itself to that. The states and the Indian nations know how to deal with that. And that kind of process is what is going to occur in Oklahoma. Okay, I sidetracked, didn't I? Look what the Allotment Act did to Indian nations, folks. The allotment era is considered to be an absolute disaster, and Congress ended it in 1934. But in that time period, tribes lost 90 million acres of the 130 million they had owned when the act was enacted. And notice this, George Washington would be proud of this next point, I think. The lands the tribes were left with were nearly worthless. Desert or semi-desert. Are you shocked? What did George Washington say was going to happen? What was the policy of the United States for nearly 200 years? And so here's my last point. The US worked for it. Treaty promises, be damned. Is it okay, Patrick, that I say the word damned? Oh, I should be careful. Okay, finally, I'm going to get you to the McGirt issue. And the Supreme Court test for when a reservation is deemed to have been diminished, when the borders are made a little smaller, or the word we use in the law, when the reservation is disestablished, completely erased. Oklahoma's argument was that the Creek Nation reservation was completely disestablished, completely erased, and the only lands that were left to the Muscogee and their citizens were a few acres here and there. So the test that the United States Supreme Court has devised to answer this question, this kind of issue has been in front of the Supreme Court 9 times, folks. In the 5th of this chain of 9 cases is the Solem case, also brought by a criminal defendant. Was the reservation still in existence? So the Supreme Court looked back at the previous 4 cases to see how they had analyzed this issue. And now in Solem versus Bartlett, they set forth what everyone thinks was a 3-part test. I've taught Indian law since 1993. I've taught Solem versus Bartlett since then. We all think it what created a 3-part test. And this test is what was going to be applied in McGirt. Was the Muscogee Creek Reservation completely disestablished by Congress at some time in the past? So here's the 3-part test that Solem set out and that everyone expected the McGirt court to apply. What did Congress say? Now, I don't want to take you back in the slides, but remember what I said under the treaty clause provision. In the Lone Wolf case in 1903, the US Supreme Court said Congress can abrogate Indian treaties. So that's what the first question of the Solem test is. What did Congress say? What did it do when we think it might have diminished or perhaps completely disestablished Reservation X? So we analyze the specific language. When I teach this subject, I say there's some language the court has often pointed at as being the magic language that creates a nearly irrebuttable presumption that the reservation did diminish or was disestablished. So we look for congressional intent and express language. If there's not that kind of language, the Solem court said, well, we will look at what we today call legislative history, folks. What was the contemporaneous events? What did senators and members of the House think? What did the committee report say? What perhaps even did the public think? What did tribal leaders think? What did the governors and the citizens of whatever the relevant state is? What did they think this new act of Congress had done? Was the contemporaneous understanding the res would shrink? Okay, and here's the part of the Solem test that I always rail against, that I detest. The court said, we'll even look at subsequent history. What happened to the reservation in the 100 years after Congress maybe did something to the borders of the reservation in that act from 1890 or 1910 or 1920? And then, of course, the court said, we will even look at the demographics of the area. How many non-Indians live there versus how many Indians? Well, the reason I rail against that one, folks, is that American Indians make up 1.5% of the United States population. Sounds like a demographics test is kind of ridiculous. But let me make this most important point to you. The court repeated in Solem, as it had said many times, an allotment act by Congress does not diminish or disestablish the reservation borders. So the fact that Congress chose under the General Allotment Act to break up a reservation into smaller pieces of land and allot those pieces to the individual citizens of that tribal nation did not, and Congress never intended, an allotment act to affect the borders of the reservation. This becomes crucial in McGirt, folks. So here, we're finally to McGirt. And let me start with just a little bit of history first. Well, let's see, let's not get ahead of myself. Let's start with this then. So Justice Gorsuch writes the majority opinion. It's a 5-4 decision. Now that Ruth Bader Ginsburg has passed away, Amy Barrett, it'll be interesting. Apparently she has done no work or research in Indian law. A lot of people look to see what she might think about Indian law. She apparently has no background in it. So she's an unknown quantity as far as what she will think about Indian law and how she might rule. Justice Gorsuch, on the other hand, came from the West. He was 10 years on the 10th Circuit, which is Oklahoma, New Mexico, and some of those states in the western part of whatever you want to call that. He had written and been involved in at least, I think, 10 Indian law decisions when he was a 10th Circuit Court of Appeals judge. And so Indian country was a little happy when he was on the court, because here's somebody that at least knows something about Indian law and is from the West and understands a little bit maybe about the current existence of Indian nations and Indian sovereignty. So he writes the majority opinion. Since he's been on the court in April 2017, he has voted at least 3 other times in favor of tribal arguments in front of the Supreme Court. So he followed the first step of the solemn case of the test. He looked for express language of Congress. The majority finds no express language of Congress to either diminish or to completely disestablish the Muscogee Creek Reservation. Now, Oklahoma's argument was based on the Allotment Act, the Creek Allotment Act of 1901, and various other acts that occurred around that same time. Oklahoma and the dissent, written by Chief Justice John Marshall, screamed to high heavens that if you look at all these various laws and what happened, they claim there's no question that Congress did intend to disestablish the Creek Reservation. But Gorsuch looks at the relevant acts, and primarily the most relevant one is the 1901 Creek Allotment Act, an act Congress passed specifically for the Creek Reservation, and all it did was allot the reservation. What has the Supreme Court said multiple times? Allotment alone does not change the borders of the reservation. And now here, I want to give you just a little background. In 1893, Congress established a congressional commission to go to the creek and to try to buy creek lands. This commission spent about a year in Oklahoma, in the Indian Territory, it was not yet Oklahoma, trying to get the creek to sell land. The creek leaders said absolutely no. The commission goes back to DC, reports to Congress the Creek Nation will not sell any land. In lieu of that, Congress then enacts the 1901 Allotment Act. So the majority looks at that history. Look how important history is, folks, to then Indian law and the current existence of a tribe this size with these kind of powers, etc. So to me, it's interesting. I'm a frustrated historian. I'm a lawyer, right? A law professor, but a frustrated historian. So it's delightful to me to how much overlap there is. So the majority had no problem saying Congress never intended to change the borders. All Congress did was allot the reservation when it found out it could not get the Creek Nation to sell any land. So the Creek Nation was never expressly or clearly, remember, that's this #1 test of Solem. What did Congress say? What's the specific statutory language? And when I woke up the morning of July 9, 2020, my wife says, you guys won that case. And so I downloaded it and I read that sentence, folks. That's the first sentence of Gorsuch's opinion. I knew, well, yes, I knew my wife was right. The tribe had won the case. On the far end of the Trail of Tears was a promise. That's a treaty promise, folks, that the Constitution says is the supreme law of the land, dominates over anything a state or city or county might want, and should force the federal government to comply with that treaty promise if they've never abrogated or changed or altered the treaty itself. Let me look at the clock, stay on time here. Let's see. I think we're doing just fine. So what does the court hold? The reservation boundaries from 1866 are still intact. This entire area is still Indian country. That's a term of art, folks, as defined in 18 U.S.C. 1151A. And I told you I've taught Indian law since 1993. I've always stated in my classes, and I was correct, that the Indian country in Oklahoma was defined by 1151C. Allotments, those small pieces of land that was allotted from the larger reservation, if that land was still held by an Indian person or by the tribal nation in trust with the United States, then that was Indian country under 1151C. But what the McGirt decision tells us is that the Muscogee Creek Reservation is Indian country under 1151A, which is about reservations. So I've been trying to research, I don't have an exact answer of this. I think before McGirt, the Muscogee Creek Nation itself only owned about 7,000 acres in trust. Individual Muscogee Creek citizens owned about 128,000 acres in trust with the United States. So the Muscogee Creek Indian country was barely 135,000 acres under 1151C. On the morning of July 9th, we found out that the Creek Reservation is 3,250,000 acres. That and under 1151A. That's what I'm calling both a bombshell and a big change all at once that everyone has to deal with. The Muscogee Creek Nation, this is a challenge for the nation, for Oklahoma, for the United States, for the other tribes in Oklahoma. This is a change, this is a challenge. Now I want to point out the Supreme Court always carefully defines what its answer, what question it's addressing, to keep an opinion as narrow as possible, because Supreme Court opinions get analyzed the way I'm doing this one right now, and they get spun out of all reality maybe. And so the court was only asking if Oklahoma or the United States had criminal jurisdiction over what Mr. McGirt did when he committed his crimes on what we now know was the Muscogee Creek Reservation. It's still a reservation. For purposes of federal criminal law, it's the feds that have criminal jurisdiction. The tribe would have also concurrent criminal jurisdiction over Mr. McGirt. An Indian who commits a crime in Indian country is subject to the criminal jurisdiction of both the feds under certain statutes and under the tribal government under its inherent sovereign criminal jurisdictional power. But here's from the opinion, here's what they said. Congress has not said otherwise. This is still a reservation. We hold the government to its word. Wow. For tribal advocates such as myself, Indian law professors, and of course for the Muscogee Creek Nation, I call this a bombshell. Now, what about, remember, we talked about Solem Part 2 and 3. Did the court apply Solem Step 2 and 3? I said back here, under Step 1, there was no express statement from Congress that it intended to change the borders of the Creek Reservation. I'll let you read this. I don't need to read it to you. The majority does not apply Step 2 and 3 of Solem. They discuss it still somewhat. I mean, when you write a judicial opinion, you want to show you're right. So you often will address arguments the dissent or one of the parties raised, and you will knock it down. Oh, that doesn't even matter. But look what Gorsuch wrote. The state claims we're not done. We're supposed to look at Step 2 and 3 of the Solem test. This is mistaken. Now, I want to raise to you folks, I'm certain you're all aware of the arguments about textualism, originalism. I believe Justice Scalia and before him, perhaps Professor and Judge Robert Bork were maybe the prime advocates of how to interpret statutory or constitutional language. Do not consider what we would call legislative history. Do not look at other sources. Just read the language and interpret that. Only if that language is ambiguous should you look to other evidence. So Gorsuch is an avowed textualist, an avowed originalist, but so are all four of the dissenters. I wish I could have a private conversation with the four justices that dissented. What happened to their advocacy, their adherence to originalism, to textualism? But you can see that Gorsuch does not follow Solem Step 2 and 3, that I and every legal commentator and judge would have thought use all three steps of Solem. They say the only step proper for a court of law is the clear language of Congress. Here, Congress did not intend to diminish the Creek Reservation, so it still exists. And there you can see the rest of the quote. So let me check the clock again. I've got just a few slides left. Okay, I want to show you this. So let's see how this is the majority's view of what Oklahoma and the dissent claim had happened. Remember, the dissent doesn't even claim that there's one act of Congress that diminished the reservation. To me, that cuts enormously against their argument. If Congress never expressly stated in one act that it meant to get rid of the Creek Reservation, how are you going to cobble that together from a lot of other extraneous acts? And that is what Oklahoma and the dissent say. So I'm going to give you a slide here and let you just read it. This is the language from the majority opinion, slightly describing what happened in Oklahoma, why people thought the Creek Reservation and all these other tribes there, that their reservation borders are gone. And then the majority says why that is totally wrong and totally erroneous. So here's the argument. Oh, there are practical advantages to ignore what Congress wrote. How much easier just to assume the state can do what it always did. But here's what he says happened in Oklahoma. Indian landowners lose their titles by fraud. There is no question that there was egregious fraud and graft in Oklahoma, folks. I read a sentence not long ago by a very famous Indian historian, is Catholic priest, Marquette University professor who passed away, but I think he's the most prominent historian of Indian history in the U.S., with the U.S. He wrote that if an Oklahoma Indian had oil under their land, they were deemed to be incompetent. And the attorneys, and it's even alleged the courts in Oklahoma, the probate courts, were involved with taking these lands from Native peoples. That is what Justice Gorsuch is referring to right there when he uses the word fraud. But look the rest of what he says. Pretty soon we all forget whose land it was. We just assume it's part of Oklahoma. Then the reservation becomes even far-fetched. And that's where we were until July the 9th, folks. That's where Oklahoma was. It's far-fetched to think there are reservations in Oklahoma. But look what Gorsuch and the majority say. The job is done, a reservation is disestablished. None of these moves would be permitted in any other area of statutory interpretation, and we will not do that here. That would be the rule of the strong, not the rule of law. Folks, American society, American legal arena, we pride ourselves that we do exercise and obey the rule of the law. And this is what Gorsuch is saying. If Congress never shrunk the borders of the Creek Reservation, even if it's inconvenient today for Oklahoma, the borders still exist. So that's the holding. Now I'm down literally, this is my last slide, and I think I'm not over time yet, folks, and then I'm gonna make just some predictions. Future cases, these other, the 5 civilized tribes, I told you, Seminole, a trial court in Oklahoma has already held that the boundaries of the Seminole Reservation still exist. How about these other 3 very large tribal reservations? How about my own tribe, the Eastern Shawnee tribe of Oklahoma, and the other little tribes in the northeastern? I say little because our reservations were little. My tribe's reservation was about 14,000 acres in 1888 when we were allotted. And once again, when everyone then thought the whole idea of an Eastern Shawnee reservation just sort of disappeared. Go back to this language that Gorsuch said, how this happened about the Creek. Same thing about the other tribes in northeastern Oklahoma and elsewhere. The Oneida Nation in Wisconsin, they had lost a federal trial court decision that said their res had been diminished. Or I've not read that opinion. Maybe it was completely disestablished. But in the 7th Circuit on appeal, they reversed that bad decision for the Oneida Indian Nation, and they won. And the 7th Circuit Court of Appeals cited the McGirt case. Another tribe has a case pending in front of the 6th Circuit, where it also lost in the trial court, district court level, and its reservation was disestablished or diminished. Again, I've not read that, and I don't know which it is. And that case is pending on appeal in the 6th Circuit. But now I want to give a few little warnings. Don't forget, Congress could tomorrow pass a law that diminishes or disestablishes the Creek Reservation. Oklahoma has already asked for that to happen. Would President Biden sign such a bill? Would such a bill pass the House with the Democratic majority? I don't know. I think the risk of that has gone down a little with President Biden, but I am almost more concerned, would the Supreme Court change its opinion? We know the Supreme Court doesn't like to change its opinion too often. That looks bad when the Supremes say they did something wrong. But I've got to point out to you that Justice Thomas, just 2 weeks ago, wrote this in an opinion that's called a dissent from a denial of certiorari. So there was a case presented to the Supreme Court about taxation issues and regarding Indian country and Indians, and the court refused to take it. So they denied granting certiorari. But Thomas wrote a 2-page dissent to not taking on the case. And he wrote this. He quoted the dissent in McGirt. He said, we should take this case because these are the kind of issues that are coming up because of McGirt. And look what he wrote. So he has obviously not gotten over the McGirt decision from July the 9th. He's still thinking of it. And what might the court do now that Ruth Bader Ginsburg has passed and there's a new justice on the court? Let me give you just one little warning. The Supreme Court has a few times in its history very quickly reversed various cases. I'm aware of the Jehovah's Witnesses cases. 1940, there was a decision about Jehovah's Witnesses not saying the flag salute, and the Supreme Court changed its mind 180 degrees within 3 years, 1943. There was another case about religious free exercise of religion regarding Jehovah's Witnesses, and the Supreme Court changed its mind from an 8-1 decision to a 6-3 decision in favor of the Jehovah's Witnesses in 1 year. So there are examples of the Supreme Court quickly changing their mind. Now that's my last slides, but let me just give you some quick predictions. What might change? The sheer size of this reservation is an enormous change. The criminal jurisdiction that the Muscogee Creek Nation and the United States now have over this area, and that Oklahoma does not have over Indian defendants. So remember, it's a limited issue. Oklahoma can still govern its citizens that are non-Indians, but Indian peoples that live within the reservation are subject to a lot more jurisdiction and power of the Muscogee Creek Nation than they were before. Criminal jurisdiction. Civil jurisdiction, which is everything you and I know governments do. Tax, regulate, zone, you name it. These powers the tribe will now be the primary government over this area. How will they interact with Oklahoma? How will changes occur? Will it be disruptive or will it be done cooperatively? The majority opinion and what Justice Gorsuch wrote was, one can hope these governments will coordinate their efforts and they will work together. Gorsuch even mentioned an interesting point. He said, yes, as the jurisdictional powers move and adapt to the McGirt decision, maybe Oklahoma will find out it has too many criminal prosecutors, public prosecutors, and maybe the United States and the Muscogee Creek Nation will find out they don't have enough. So there's obviously going to be a time of change. But I just want to repeat what I said. States like Oklahoma, Montana, any state with an Indian reservation, they have learned how to deal cooperatively with each other and how to govern and share jurisdiction and governmental powers. Oklahoma has already been doing that with tribes. There are hundreds of agreements between the Oklahoma state government and the 39 federally recognized tribes located in that state over things like gaming, tobacco, licensing cars, et cetera, et cetera. So these issues have a paradigm, have a model for how to handle them. I just want to give one more example, and then I think I am getting close to my time. The Indian Child Welfare Act, folks, enacted by Congress in 1978, to give tribal governments and tribal courts a larger voice in the control of adoptions and foster care placements of Indian children. The act, I believe it's section 25 USC section 1915A, says a tribal court has exclusive jurisdiction over an adoption or child care placement question of an Indian child if that child is domiciled in Indian country on that tribe's reservation. So now the Indian country from Muscogee Creek just went from that 135,000 acres that I think it was to 3,250,000 acres. That is an enormous expansion of power and jurisdiction and responsibility for the Creek Nation. So that's why I say it's a challenge for the Creek Nation too. And so will the United States, will Oklahoma, will we see a cooperative, diplomatic negotiation and working this out for the best of everyone, or is this going to become a problem? Anyway, I think I do want to end there. This is the bombshell, big changes. We'll hold our breath what to do about it in the future. Thank you very much.
Great. Thank you, Bob. And thank you all for tuning in. We have over 200 people listening to your talk, Bob, which I think just shows how fascinated and interested and important this decision is and is going to be even more so in the future. And so we have a lot of questions. I have one just to start it off, and it's my own coming in response to your predictions. And in a very practical way, how do states and sovereign Indian nations negotiate on the state level? You know, the federal government has a State Department. They're tasked with diplomacy. What you're talking about sounds a lot like diplomacy as well as coordinating law stuff. So how do these states actually manage those relationships in a very kind of administrative and practical way?
Quite a few states, Patrick, especially in the West, they will have some kind of aide to the governor whose portfolio is to deal with the Indian nations in that state. A pretty good friend of mine is the governor's assistant in Michigan. So Oklahoma, obviously, I don't know this, I'm guessing, has somebody like that already. When you have 39 federally recognized tribes in the state, Oklahoma is engaged in diplomatic negotiations with tribal nations all the time. So I truly hope this is not going to spin out of control. I hope that the governance and government of Oklahoma, the feds, and the tribe will work this out in some diplomatic, logical way.
Great, thanks. So we have a ton of questions. I'm going to ask as many as we can. I know some people may have to leave because it's 2 o'clock. The first is coming from Tim King, and I don't know if you can answer this, but it's a question I think I wanted to ask, which is, you mentioned Ruth Bader Ginsburg, and Tim King mentions that she sometimes cited the doctrine of discovery in her decisions. So I didn't know if you could talk a little bit more about her own judicial philosophy when it came to Indian law and maybe how it changed over time or didn't.
Absolutely. The papers that I think Kyle Roberts posted, I have written about this already. None of these are out in print yet, so you have to see them online at SSRN. I've written about this. One reason I thought the tribe would not win the McGirt decision is because of Ruth Bader Ginsburg. Tim mentioned that in 2005, in what's called the City of Sherrill case, Ginsburg wrote the opinion. She held against the tribe, the Oneida Indian Nation in New York. And in her first footnote, number 1, she cited this doctrine of discovery that my first book is about, this international law principle that Europeans could colonize, settle, and govern the entire world. That doctrine of discovery was applied here in the US in 1823 in the case of Johnson v. McIntosh. She also wrote another opinion that I have to teach all the time that severely limited tribal court adjudicatory jurisdiction, the Straight decision, S-T-R-A-T-E. So I was not certain she would be a vote for the tribal position and for Mr. McGirt in this case at all. So I shared the same concern that Tim, I think you said King, Mr. King had. Great.
Another question from Marta Gutenberg. And she was wondering if you could talk a little bit more about what held in trust means. What does that actually mean in terms of ownership? And her specific question is, does that mean that the federal government could take it back if they want?
In American and Anglo-American property law, land and other property can be held in many different estates. We call it an estate. And so if you're familiar with someone being appointed a guardian or a conservator or a trustee for an incompetent person, the legal owner is the trustee. So if that's a bank, let's use that as the best example. Banks are often appointed to be the trustee for either a minor or an incompetent person. The legal owner of the property is the bank. And so, and we call that it's held in trust. For the trust, for the protected person, the bank's the trustee. So the United States, because of Johnson v. McIntosh, so we go back to Tim's question, because of the doctrine of discovery, the United States has always been deemed to have a property ownership right in Indian lands. And today we call that the land is held in trust. The United States is the predominant legal owner. The Indian nation or the tribal individual is the beneficial owner. The United States is supposed to manage the land, protect the land for the benefit of the beneficiary. Now, the rest of her question isn't quite on this point of land, but if Congress were to take the Creek Reservation today, if Congress were to pass a law now diminishing or disestablishing the Creek Reservation, I am certain there would be a Fifth Amendment takings claim that would follow. The tribe would sue for money damages for the United States taking private property, the tribe's land rights, for a public use. And this is very well understood that when governments take private property, they have to pay due compensation. That's the Fifth Amendment of the Constitution.
Great, thank you. We still have 150 people tuned in, so I'm going to keep going if you don't mind, because there are a ton of questions. We're not going to be able to get to all of them, but I want to ask a few more. So another one comes from Amy Den Ouden. She says, extraordinary. Thank you for emphasizing this point about the textualists. But then she asked about the notion of the savage as wolf and its underlying assumption of the irrelevance of Native people and their rights. How does this notion that Washington expressed in 1783 account for the hypocrisy that seems to have followed in the years all the way since? I don't know if you can comment a little bit more about that.
Well, that's Professor Den Ouden. Hello, Amy. Thank you. Boy, that's a professor question that's almost too hard for me to answer. So I'm not quite sure what you mean by the hypocrisy that's fallen away. So the United States always presents itself as this idealistic rule of law governs and we take care of everyone, but we know throughout our history, let's talk slavery, let's talk all sorts of issues, and let's talk what the goal of the United States was towards Native people. So on one hand, it's, gosh, let's sign treaties. And the treaty is the supreme law of the land, Article 6 of the Constitution. You can have your lands forever until next week when we want to take some more. So Thomas Jefferson, in my first book, he was pretty devious. Since he was the president of the APS for 17 years, Patrick, I hate to disparage President Jefferson too much, but he was devious. And in his private journals, you can see his goal was to get Indian lands as cheaply as possible and then to sell them to settlers and farmers as expensive as possible. He brags in his journal that he balanced the federal budget on the sale of Indian lands. While he was president, the U.S. signed 26 treaties with Indian nations. And so I'm not sure I'm answering your question, Amy, but well, what is hypocrisy?
And maybe ask what I think she's also asking, which is, do you think that hypocrisy, the fact that the treaties are supposed to be the supreme law of the land, and in many respects they honor that, the United States honors that with European nations, but that notion that the Native American, as you mentioned in your opening, is actually equated to an animal, a wolf, that therefore it makes it easier or they're more justified in breaking treaties because it's, with somebody that Washington compared to a wolf.
Well, okay, I'm not 100% certain I agree with that or that point, because go back to what I mentioned under the Chinese exclusion cases in 1882, the Supreme Court said Congress can breach international treaties.
Yeah.
Didn't President Trump take us out of the Paris Accord? I'm not an expert on that. I don't know if the Paris Accord was the equivalent of a treaty. I believe George W. Bush took us out of a treaty, so we do that occasionally, even with other world powers. But yes, I agree with you. It seems a lot easier to do that against Indian peoples who, under social Darwinism, you think is a weaker people, a weaker civilization. They're all just going to die off anyway. Isn't that exactly what George Washington's letter said?
Great, thanks, Bob. So I'm now going to come at you with a number of questions. I'm going to compile into one. If you have a pen, you might want to take notes, because a lot of questions are getting more at what this means in various different aspects. So several people ask, what does this mean for areas outside of Oklahoma, Alaska, Montana, places like that? And the second question, what does this mean for water rights, which, as you know, are so important and also contested right now? What does this mean for individuals who maybe non-native citizens who maybe are sitting on property that was previously owned by an Indian individual or community? And then more specifically, how extensively do you think the McGirt case will lead to retroactive assignment or return of tribal sovereignty to lands? So I know that's a lot. I don't know if you can just kind of punch through them, but there are a lot of these questions on these lines.
Yes, very interesting. As I already said, the McGirt decision was cited in that Seventh Circuit case that the Oneida Indian Nation of Wisconsin just won. So remember, the Supreme Court case is only about the McGirt's claim and the Muscogee Creek Reservation. So it does not apply directly to any other tribe. What it shows us is look for the language of Congress, study the history, what happened. If Congress never changed the borders, they still exist. So I do not know how many of the other 574 federally recognized tribes in the United States might have a McGirt type argument, but it will be based on what Congress did to that tribal nation, what Congress said, and so that's what we'll have to look at. The water rights question is wonderful. I just taught water rights for a week. Water rights for tribal nations is based on the amount of irrigable acreage they have within their reservation. And it's based on the treaty language and the purpose of the treaty. So you made me think back. Look at what I just showed you today. The Creek Reservation is supposed to be a permanent homeland for the Creek people. It's now 3,250,000 acres. The water issues could become enormous. So that's non-natives. Here's what I want to strike down. When July the 9th, people in Oklahoma were going, gee, do I lose my house? I mean, that's what the newspaper was reporting. No, a non-native person who lives on land they own in fee simple inside that 3,250,000 acre will see very little change. The Supreme Court has developed important tests that have been around for a long time. The Montana versus United States case from 1981 defines when a tribal government can regulate, pass a law that impacts a non-Indian for their conduct on their non-Indian owned fee land. And the courts since then have not recognized very much power by tribal governments over non-Indians for their conduct on non-Indian owned fee land. So most Oklahomans, even if they live within that 3 million acres, won't feel much change. But there is a new kid on the block, to make a little joke. There's a new government that sometimes might have power, jurisdiction over that non-Indian. So there is a change, but it's not as terrible or dramatic as the newspapers made it sound July 10, 12, et cetera. I think that's.
Yeah, one last question, and I know there are a lot of other ones. We'll share these with Professor Miller, and be able to have some of them responded to on our YouTube channel when we post this video. And this video will be posted online. The last one is actually, I was thinking about your own career, and I know you've been a tribal judge often. What, on a day-to-day basis, how has that work changed, or how do you see it changing over time now? The tribal legal system and the work of tribal judges. What's going to change there?
Well, I didn't get to this point in my forecasting. I just mentioned criminal jurisdiction and civil jurisdiction. There's a third form of governmental power jurisdiction that we call adjudicatory jurisdiction. And that's what Ruth Bader Ginsburg decision I mentioned earlier, the Strait decision. How much power did the tribal court system have to hear a car wreck that happened on the reservation of the 3 affiliated tribes in North Dakota between 2 non-Indians? And the US Supreme Court held that the tribal court could not hear that lawsuit. So that was a restriction on what's called the adjudicatory power, jurisdiction. That's all the word jurisdiction means, power, authority. What did it do to the tribal court's jurisdiction? So straight from a tribal advocate such as myself, a tribal government, we don't like the Strait decision. But these 2 non-Indians had to take their car wreck case to the North Dakota state court system. So you asked me what I've seen. I'm only a part-time judge, so I'm not a person to comment too much on this. I've found most tribal courts now use tribally or legally trained judges. The courts, they're more mature, there's more development of tribal law, and the courts I'm familiar with, you almost wouldn't know you're not in a federal or a state court. So I want to tone down people's fears of tribal court and what goes on there. So I hope that addresses your question, but I'm not a full-time tribal judge, so I have not watched the evolution of the past 30 years, but I have been a tribal judge very part-time since 1995 in various courts. And so I will tell you that the rules and the law applied, you might think you're just in a state court in some instances. So it's not that much to fear. In fact, Patrick, let me end with this. There's been several studies that non-Indians, the statistics show non-Indians are treated fairly in tribal court. And there should not be this fear that it's some kind of something else.
Great. Thank you, Bob. This is really a fascinating talk. Really appreciate you taking the time to share your knowledge with the rest of us. And everybody else, I hope you will tune in to our future talks. Next one is December 8th and another one on the 9th. And check us out on the web, amphilsoc.org. Thanks again, Bob. This is great.
Thank you all very much.